Hello and welcome. I'm Anthony Folan, and today we will be facilitating a compliance training session in relation to workplace violence and anti-harassment. Working with your leadership team, we have put together a comprehensive presentation that will cover all elements from a legislative standard compliance standpoint. So what I'll do is I'll share my screen and kind of walk you through the presentation. At the conclusion of the presentation, you'll be asked to complete a quiz so we can confirm that everybody has an appreciation of the topics and the learning outcomes. From an agenda standpoint, we're going to review the framework of workplace violence and harassment from a company perspective. We're going to take it from a legal perspective, legislation under Bill 168, Bill 132, and this relates to firms in the province of Ontario that employ obviously 5 or more people, which we do. We'll talk to you about some typical examples of harassment in the workplace and how, in the event that you feel subject to harassing or inappropriate behavior, how to address those allegations, and we'll reinforce how they will be investigated at the same time. As we alluded to earlier, workplace anti-harassment, workplace violence, legislation continues to change and to be updated. So we'll cover the regs from a Bill 168 and Bill 132 standpoint. And if you're an employee on the front lines, there's obligations under the Occupational Health and Safety Act that you have. If you're a supervisor, there's a raised level of expectation in relation to making sure people under your direct supervision have a chance to work in an environment free from inappropriate behavior and certainly free from harassment and workplace violence. And senior leaders in the organization, then obviously their standards are exacting when it comes to creating the appropriate environments free from harassing violent behavior. Unfortunately, and these numbers I believe have become more pronounced during the pandemic, certainly surveys indicate that 1 in 5 women have been harassed at work over the last year and 1 in 8 men. It's an unfortunate reality that we're facing today. And these are just the reported cases. In many cases, there's some uncertainty and hesitation when it comes to reporting inappropriate behavior in the workplace. We want to make sure that you have that appreciation and level of confidence as we go through this presentation. For the purpose of this survey, when we talk about harassment, we're not talking about whether or not somebody said good morning to me or invited me out to, as part of a group for a social interaction. We're talking about threatening behavior, humiliating, intimidating behavior, and unwanted sexual harassment or attention. Verbal abuse, physical violence, sexual harassment, unwanted sexual attention all constitute certainly potentially harassment in the workplace, and we'll give you those definitions in a moment. And unfortunately, the harassment was certainly more pronounced among women and men who identified as either homosexual, bisexual, compared to heterosexual, and certainly more pronounced in the Aboriginal community. And quite often targeted groups, minorities, or that they're targeted in relation to inappropriate behavior in the workplace. Hopefully, as a result of the education and awareness, we continue to address and eliminate that behavior in the workplace. Sometimes it takes a little while to publish the stats, but this is for me, a compelling slide. Respect in the workplace in 2016, Bill 132 came into effect, where more pronounced regs, responsibilities, duties the employer has. There's certainly been more awareness, whether it be through social media, whether it be the news outlets. And as a result of the changing regulations, as a result of the raised level of awareness, as you can see in the province of Ontario, the number of harassment complaints submitted to the ministry spiked. And they've continued to spike, as I mentioned, since 18 right through to present day. And during the pandemic, certainly more pronounced. I want to take you back to 1999. And the reason I want to take you back to 1999 is because of an unfortunate event that took place at OC Transpo in Ottawa, Ontario. And at the time, under the Occupational Health and Safety Act, there was no reference, no jurisdiction to manage or regulate workplace violence and acts of harassment in the workplace. Pierre LeBrun, 12-year employee, parts clerk, he had some mental health issues, pronounced stutter, facial tics, And at times when he was stressed, his behavior became, again, more pronounced. He complained to the HR department, the occupational health and safety nurse, his doctor, supervisor of the union. He was teased, he was ridiculed, he was mimicked, and unfortunately, nobody responded appropriately. Ultimately treated for depression, and ultimately committed an unforgivable act. He walked into the OC Transport building on Saint Laurent Boulevard in Ottawa, high-powered hunting rifle, shut the place up, killed 4 workers, wounded 2 others, killed himself. Little police responded after the fact. I think this is compelling. The letter that he submitted, or he left. I'm going to commit an unforgivable act. I've got no choice. I'm tired, exhausted, and completely backed against the wall. They'll never leave me alone. I can't go on living like this. They destroyed my life. I'll destroy their life. OC Transport and the unions can't hide behind what they've done to me. They'll pay dearly for what they've done to me. The people who I hold responsible are, and I won't name them in this submission, along with many others. All I wanted was them to leave me alone, not to bug me, but it was too much to ask. They spread lies, especially that I was a rat who denounced my own union. All I wanted was them to stop laughing at me, stop ridiculing me. It gets worse. He had actually, Pierre spoke to a coworker in advance of the incident, asked where it would be an appropriate place to shoot up the facility. And you'll see the coworker ultimately committed suicide. I've been unable to sleep well since the shooting at OC Transport. The gunman Pierre talked to me in great length about where it would be more appropriate to shoot up the management team. As it turned out, he shot himself at this location in this loft. I feel guilty as hell. And obviously just the fallout. There was a post-event analysis by a forensic psychiatrist, Dr. Peter Collins. Pierre LeBrun worked in a poison workplace. He was repeatedly harassed due to his speech impediment, tic disorder, complained about the ridiculing to a number of individuals. The personal factors of speech impediment, tic disorder, poor self-esteem, anxiety, depression, and paranoia, exacerbated by the workplace factors of chronic harassment and ridicule, proved to be a fatal combination. So it was a poison work environment. We have someone that was picked on, ridiculed, mimicked for year after year after year, and it ultimately resulted in a fatal outcome, a tragic outcome. A little while after that, Southwestern Ontario, Hotel Dieu Hospital, personal relationship in the workplace. Dr. Mark Daniel was a doctor that was on board, and Lori DuPont was a nurse that worked together. The relationship, they kind of went in their separate directions and went apart. And he started to harass. He started to make life difficult for Lori DuPont. Again, she reported to the administration, and they basically said, kind of, this is not a work-related situation. You're big boys and girls, kind of grow up and manage it accordingly. They put a bit of safety plan in play, but to no avail. And ultimately, they were working together on a similar shift, and he stabbed her to death at the hospital. Then he took his own life. So the government says, in the province of Ontario, people are being killed on the job. In the province of Ontario, people are being subject to harassing, violent behavior. And as a result, Bill 168 came into play. And the government now puts regulations under the Occupational Health and Safety Act in relation to requirements that employers have to protect all employees in the right to work in an environment free from harassment. And let's face it, some of the situations are not as significant as what we've just addressed at Hotel Dieu and as well as OC Transport. But in any organization, inappropriate behavior impacts and leads to health and safety issues. Could be distracting for someone that's preoccupied performing a dangerous task, preoccupied with bullying, preoccupied with harassment. Could be physical or psychological injury, lower productivity, low morale, absenteeism, turnover. The impact is significant, and it has a cost. That's why we have an obligation to manage it accordingly. So from a company standpoint, we're committed to ensuring that all employees are protected in their right to work in an environment free from all forms of harassment, sexual harassment, workplace violence, and discrimination. Why? Because it's the right thing to do. Why? Not just because we have an obligation. From a culture standpoint, we want people to feel comfortable at work, that obviously going to be protected in their right to work in an environment free from harassment. When you look at the definition of harassment, we subscribe to the human rights definition. We subscribe to the employment standards definition under the Act. And it really, harassment means any engaging in a course of vexatious comment or conduct that is known or reasonably to be known to be unwelcome. Well, why is it known? It's known because I've told you, we've told you, we've put this program in play. We've provided education, awareness, and training. Or in our community, we should know better. And I'll talk about that in a moment. Discrimination occurs when decisions are made against an employee based on one of the prohibited grounds under the Human Rights Code. And quite often I get called into an organization and someone says, I'm discriminated against. They're discriminating. Well, what are the grounds? Is it age? Is it race? Is it gender? Is it orientation? Is it your religious beliefs? So we'll give you a bit of a broader definition in a moment. We talked earlier about Bill 132 coming into play, and the government of Ontario clearly articulates and states that we have to have this language in our policies. Sexual harassment, engaging in a course of vexatious comment or conduct against a work in a workplace because of sex, sexual orientation, gender identity, gender expression, where the course of comment or conduct is known or is to be known to be unwelcome. And similar to that harassment definition. And we can't subject people to inappropriate behavior because of their sex, their gender, their orientation. It's 2021. Sexual harassment definition, making a sexual solicitation or advance where the person making the advance or solicitation is in a position to confer, grant, or deny a benefit or advancement to the worker. And we know already known that that solicitation or advance is unwelcome. In layperson's terms there, if somebody has the right or the authority to process a wage increase, process a better improved schedule, benefits, they can't say, I'll give you this in exchange for a sexual favor. It's against the law. And if somebody says, no, heck no, I don't want any involvement whatsoever, don't put me in that position, there cannot be a threat or reprisal for the rejection of such an advance or solicitation, where the reprisal is made or threatened by a person or a position that can actually carry that out. So the government takes this very seriously. It's unfortunate that in 2021, we have to have this in our policies, but the reason that we have to incorporate this language into our policies is because it's happening. This behavior is taking place across the province. Workplace violence, broken down into three elements: the exercise of physical force by a person against a worker in a workplace that causes or could cause physical injury, or an attempt to exercise physical force against a worker in a workplace that could cause physical injury. And the final element is a statement or behavior that is reasonable for a worker to interpret as a threat to exercise physical force against the worker in a workplace. And again, I run into all elements. And if I go back to the initial slide, it's the exercise of physical force. A little easier to manage that or to investigate that. I've exacted physical force against a person in the workplace, or the attempt. And I had one a little while ago where somebody actually threw a hammer, missed the individual, came off a bundle of rebar, came back and crushed his knee. So there was an attempt to exercise physical force. So whether it hits the individual or not, it's an attempt to exercise physical force in the workplace. And C, a statement or behavior. And quite often you get this threat: I'll do this, I'll do that. And it's not how it was introduced, it's how it's received. So it's reasonable to believe as a threat, then it's a violation of the workplace violence policy. And from an organizational standpoint, whether it's verbal threats, intimidation, off-colored jokes, racial slurs, remarks, anything that's covered under the Human Rights Code, race, religion, ability, sexist, physical assault, bullying, we just want to brace to the conscious level that it's not acceptable within the workplace. So for clarification, course could happen more than once, depending on the situation. Vexatious, and we've talked about this: bothersome, annoying, troublesome, threatening, intimidating behavior. It's a comment, something that's said, conduct, something that's done. It's known. It's known because we've educated you. We should know that's not acceptable in the workplace. And excuse me about the background noise, one of the challenges working from home. In the definition of workplace harassment, we talk about what are reasonably known to be unwelcome. There's a legal test. And in a court of law or hearing or an arbitration, quite often they would say, what would a reasonable person think about this? Would a reasonable person think this behavior is acceptable or unacceptable? And a reasonable person is not overly educated, not undereducated, and would that reasonable person think this behavior is acceptable or unacceptable? Quite often, when there's situations that occur in a workplace, it's difficult to be reasonable because we're too close to the situation. We know the people, we know the parties, we know the situation at hand. And again, if you ask yourself at the end of the day, if you truly are objective, are we a reasonable person? Would a reasonable person find this behavior acceptable or unacceptable? This happens to be, I think, the most impactful slide that I can share with you today. I've had a chance to conduct hundreds of investigations across North America. And at the end of the day, I attempt to establish if that behavior took place. And if the behavior took place, it's either acceptable, it's either inappropriate and unacceptable, or it's either harassment or violent, and it's a violation of those standards. And where does it cross the line? How do we now identify or differentiate between inappropriate behavior and harassment? Notice, and I would typically ask the question, and really we owe it to ourselves. If we establish that we're subjected to behavior that's inappropriate, we should be able to serve notice. And that notice is stop. I don't find that behavior welcome. I find it uncomfortable. I find it threatening. I find it intimidating. Shut it down. Again, depending on the nature of the concern. Intent. We go back to the action where the fellow threw the hammer. There's intent behind that behavior. Somebody physically grabs somebody, sexually assault somebody. You shouldn't have to say stop. Don't throw the hammer at me. Stop. Don't sexually assault me. So is there notice? Is there intent? And is there direction? And direction, as governed under the Human Rights Code, is everything that we've talked about. I'll just go to my apologies, the next slide. And again, if I'm being impacted as a result of my race, my color, my religion, my origin, my ancestry, physical disability, mental disability, marital status, sexual orientation, sex, gender identity, gender expression, you shouldn't have to say stop. Don't discriminate, don't ridicule, don't impact me as a result of any of those prohibited grounds. And again, it could be one time, it could be ongoing. Quite often I run into a poison work environment and they say, it's the way we talk around here. It's always been this way. Here's the language we use. Here's the slurs that we use. Here's the inappropriate comments that we exchange back and forth. It may be okay in 1970, 1980, 1990. In 2020 and beyond, it's not acceptable. And if somebody says, stop, I'm not comfortable with that language, I'm not comfortable with that terminology, then out of respect, we should address it and manage it accordingly. In the event within the organization you feel you're subjected to inappropriate harassment behavior, tell the person to stop. Let them know that behavior is unwelcome, as we talked about serving notice. And if you're not comfortable serving that notice, talk to your supervisor, talk to your manager, talk to HR to assist in that process. Complaints will be dealt with in the strictures of confidence. Keep it in mind, we sometimes may have to use names. We can't talk generically in an investigation. We can't say to a respondent, did you do A, B, C, or D? We need to be able to talk about specific events, times, and places so that we can manage it accordingly. But we will give you the confidence and reassurance. We'll manage it in the strictest confidence possible to protect the best interest of and integrity of everybody in the process. Anybody talking about harassment, complaints, or sharing information shouldn't be tolerated. It should only be divulged to a third party or somebody that's involved in the process. We typically don't get involved in domestic violence; it's out of our jurisdiction. But if somebody at work is in a relationship where they're subjected to the spousal or domestic abuse, and they come to work battered or bruised, and there's a chance that the domestic violence could carry over into the workplace, we have an obligation to put a safety plan in play. We don't go around asking people if they're being subjected to harassing behavior, but we certainly will be in a position to accommodate or put a safety plan in play for somebody that comes forward. And again, across Canada, there's quite often now many incidents of a perpetrator or a family member or someone that's an abuser stepping into the workplace to introduce harm. And many people are impacted. So again, under the regulations, there's a requirement to protect people in their right to work in an environment free from harassment. It could be a contractor, it could be a visitor, it could be a customer. Regardless of the environment that we're in, we've got to do the right thing. And in the event that there is workplace violence or harassment, introduce the appropriate remedy to address and bring some closure to the situation. And worst case scenario, and I've seen some worst case scenarios, if it's something that's not manageable, dial 911 and have the authorities come into play. And again, on an annual basis, we have to provide training and awareness so that employees have an understanding and appreciation of what the regulations are. We'll provide and update the policies. We'll post them in a conspicuous location. You'll have access to this PowerPoint and this presentation, and we'll, again, raise awareness on an annual basis. Anybody that works in a supervisory capacity has an overall responsibility. In some cases over the years, and depending on the organization, the supervisors turn a blind eye. No longer can we turn a blind eye. We have to intervene if we know that somebody's being subjected to inappropriate behavior. So at the end of the day, the organization takes a zero tolerance approach to harassing behavior, discriminatory behavior, violence of any kind. And we're all going to have our good days and not so good days. But in the event somebody truly subjects a colleague or coworker to harassing behavior, or a customer or client, if that's the case, and they're found guilty of such behavior, after an objective review and a determination is being made, they'll be subjected to disciplinary action up to and including the termination of employment. What isn't workplace harassment? Well, we reserve the right to hold people accountable. Immediate management, frontline supervisors, senior leaders can step in and talk about performance, talk about conduct, talk about safety, talk about quality, talk about responsiveness, talk about attendance management, and hold people accountable and document it accordingly. If it's done professionally, that's not harassment. Under the Act, certainly management reserves the right to run the business and hold people accountable for behavior and conduct. Reprisals. If anybody comes forward in good faith, there'll be no reprisal. They will not be impacted negatively as a result of bringing a complaint forward. And if anybody's party to a complaint, they cannot take any form of reprisal against a coworker for bringing a complaint forward. Any person who takes any reprisal against a worker because of an incident will be subjected to disciplinary action up to and including the termination of employment. So that covers our education, awareness, and takeaways. Obviously, it's not as interactive because this is a videotaped presentation. There's a quiz. I'm going to work with your administrator at the office level, and any questions that you may have, we'll kind of fill in the blanks and loop back. So on behalf of the entire leadership team, I want to thank you for your time and effort, and stay well, stay safe, and hopefully we'll just do our part in relation to making sure that all colleagues and coworkers are protected in their right to work in an environment free from harassment, discrimination, and workplace violence. Thank you, and enjoy your afternoon.